Welcome. Welcome, folks.
Thank you.
We are really glad to have everybody. I'm going to quit my mail so that I don't hear all those dings and so forth. And so I wanted to welcome you all and just tell you a minute or two about what kind of how this came about. And about myself, and then I'm going to let Leonard Van Slyke introduce himself. Many of you may already know him. If you don't, he's a great person to get to know, especially if you're doing reporting in Mississippi. So I teach journalism here at the University of Mississippi School of Journalism. I was a reporter for quite a few years. We're not going to count how many. In Mississippi, weekly newspapers, daily newspapers. I was a reporter in South Carolina, which is not, even though it was a bigger paper at Charleston, it's not that different from, South Carolina's not that different from Mississippi in terms of its open records and meetings laws and its openness to openness, if you understand what I'm saying. So I have been sort of in the trenches as a reporter, trying to get information, trying to tell people. I was lucky enough to have always worked for editors who were really committed to this as well and willing to back me up when I was asking for information, seeking information. Even as a teaching journalism, I try to, and I also am author of a book, so I used some of the freedom of information laws and open records laws when I was doing some of my research too, just to track down, it was more history than journalism, but to track down some of the bit of information that I needed. And as the COVID-19 pandemic kind of unfolded, I, along with some of my other journalism colleagues, were just feeling so sort of, it was such a scary kind of thing watching this wave start to crest above us and not having access to information and not seeing public officials being committed to informing the public like we think they should be. And so I decided to do something about it, which was, it makes it so much easier to have a kind of, any kind of webinar or Q&A or conference with Zoom once I'd taught my classes. So I decided to do this so that, because I knew that some younger journalists out there that I might have taught or the age they may be like I was when I first started, really unsure about what should be available, and so I thought, who better to go to than Leonard Van Slyke. And he's a longtime media attorney. He runs the hotline for journalists. Well, it's really, the big misconception is that open government and open meeting laws are just for the press or just for the television or just for the media. And please excuse me if we have some TV reporters or online reporters, please forgive me if I say press when I mean media. I'm really working on that, but I mean all of you. It's for citizens, it's for everybody. And I used to, sometimes when I was a reporter and trying to get information out of a clerk who wasn't sure about what she could give me, and say, oh, we can't give that to the press. And I'd say, well, pretend I'm a citizen, because I am a citizen, and this law applies to citizens too. And residents, not just people with legal, I don't mean just legal citizen status, but residents. So I'm going to let Leonard introduce himself and tell us a little bit about what he does. And then I'm just going to kind of walk through some of the most common issues, and then I'll open it up for questions. So Leonard, take it away.
Okay, Ellen, just very briefly, I was a reporter for several years, last couple of years of high school, all of college, all of law school, with the Hattiesburg American and the Oxford Eagle. And I then, as obviously became a lawyer, and I have now been practicing law. It will be 50 years in August. About 40 of those years I have been representing the media. And that, as Ellen mentioned, I do handle the Mississippi Center for Freedom of Information hotline on public records and open meetings. And so you're free to call at any time, and I can hopefully answer your question if you have a question. Obviously, as a media lawyer, I handle defamation cases as well as access. But access is the topic for the day. So we'll move on into the questions.
Okay, well, thank you, Leonard. And so one of the things that's come up within with the pandemic, but it's kind of a perennial issue, is but especially with, you know, the lockdowns and quarantines and social distancing, is talking about open meetings. And if you could just tell us a little bit, first of all, what the law says about how meetings, what meetings should be open to citizens and the press, things like notification and so forth, but just kind of give us an overview of what it might be easier to say what should be closed than what should be open, because it might be shorter list, because my understanding is most every bit of the public business should be done in the public.
Well, that's correct. That's the general rule is that every meeting is open unless there's an appropriate reason for executive session. So every meeting begins as an open meeting. In order to close it, there must be a motion, and it must be for a proper reason. Those reasons are listed in the Mississippi Code. It's Title 25-41-7, parentheses 4, and then A through L. So there are just a limited number of reasons that the public body can go into executive session. The most common reasons you will hear are personnel, but personnel and litigation. But don't just take personnel as being every kind of issue that deals with personnel. There's some the exemption is very specific as to what types of personnel matters are exempt and what are not. For example, I have had cases where people tried to say, providing parking for all employees was personnel. No, it's not under the law. So you need to really look at the code section. If you have a problem, give me a call and I will help walk you through that. The other one, the litigation exemption, also is limited to strategy sessions that the public body would be having, for example, with its lawyer. So it is not sufficient for a member of a public body to simply say, we want to go into executive session for litigation. No, they need to tell us much more than that, the court has said. They need to tell us what case or that it is, in fact, a strategy session. Yes,
Leonard, let me interrupt you here. I've had boards say they're going into executive session for potential litigation, which is so wide, it's just ridiculous. Or so they need to tell you what case or specific issue that they're talking about. Same with personnel. I've had them try to talk about giving raises. To broad across the board raises or to departments or in executive session, and they can't do that. They can talk about, is that correct? They can talk about it.
That is correct. In the matter of potential litigation, there must have been an actual demand letter or threat that is real, not just oh, somebody might sue because we want to expand our boundaries. It's not that generic. It has to be specific to some actual demand that someone's made to sue.
Is that demand letter part of open records?
Well, that is an interesting question. Now the open meetings law says that public records that are exempt for open meeting purposes, but it doesn't say the other way around. So I suppose that's an open question, but I would think so long as a demand letter is just simply that, it should be subject to a public records request.
Right, and you can put one thing that you can do is put the board attorney on the spot and say things like, as an officer of the court, are you telling me on your honor that you actually have a demand letter? If you're not going to show me the demand letter, are you going to tell me on your honor that there is a true and actual demand letter? And, that's not anything you can go and enforce, but it's a way to, put them on the spot and try to hold them to account. Okay, so I'm sorry. I may continue to jump in, Leonard, but you go ahead about open. What kind of notifications do they need to give if they're going, especially if they're going to have a special meeting or going to change it?
Okay, well, if a public body meets by statute at a regular time or place or has established in its meeting minutes that it will meet at a specific time, for example, the second Tuesday of every month, then that's all they have to do for the regular meeting. In the event of a recessed meeting, a special meeting, or an adjourned meeting, they have to post notice of that meeting within 24 hours of the decision made to hold the meeting. In other words, if we're going to have a special meeting next Monday at 1 o'clock, but we decide to do that today at noon, you've got to post that notice by 1 o'clock today. Also, if you want to be advised by email, you can give written notice to the public body that you want to be advised of any special recess or adjourn meetings or any meetings of the public body, and they are required to give you such notice.
Okay, great. And so they have to post it just on the door of the courthouse, or I mean, you covered the best practice would be to get on their email list, but right. I know some of them sometimes just stick it on the door and expect you to wander by.
Well, that was the law until a couple of years ago. Okay. That's all they had to do is post it in the building in the place where they normally hold the meetings. But now there is that list that certainly any member of the media or any interested citizen, for that matter, can get notice by requesting such notice.
Okay, great. So if they go into executive session, they have to first take a vote to consider executive session. Sometimes this is confusing. They have to take a vote to consider going into executive session and discuss that if there's any discussion in public, correct?
Yes, that's right. There's actually a two-step process that they can or really should follow, but I don't see much point in holding them to the first part.
Sometimes it's confusing. If they do it, it's kind of confusing to reporters, I think.
Right. I mean, they can have a vote to go in to discuss whether or not a particular topic would be appropriate for executive session. Then they come back out, and then somebody makes the motion to actually go into executive session. And that vote will have to take place in the public, and it will be recorded in the minutes by a member.
Right. So now once they go into executive session, what can be, so they can't take any official votes in executive session. So say if they have to come out to do any action, right? Is that correct?
No, that's not correct.
Okay.
Actually, they can vote in executive session, and but they do have to record that vote in the minute if they take it. Now, the problem we sometimes run into with that procedure is that the minutes don't actually have to be recorded for 30 days. So they might take an action and not actually get around to doing the minutes, or intentionally not do the minutes for till the next meeting. So that's a problem. The basic reason for that, as it's been expressed to me, primarily relates to personnel matters. And they say, well, we don't want to fire somebody and that be revealed in a public meeting before we have a chance to tell the person. So that's the rationale, but of course there are many other issues that are can be discussed in executive session that really that rationale wouldn't apply. So I would certainly, as a matter of practice, at the end of the meeting, I would certainly ask, although they're not required to announce it.
Right. And if you've been working your boards behind the scenes, you probably will have one that's willing to tell you, at least off the record, you know, what's going on and trying to see. Now, and when they have to record the vote, that means they record who voted for and who voted against, correct? It's not just 3-1.
That's right. By individual member. It's got to say for Jones, Smith, and, and whoever. And then again, the names against. So yes, by individual member, they have to record that in the minutes.
So let's talk about COVID-19 right now and other kinds of states of emergency like hurricanes and so forth. What kind of leeway do they have, and what should reporters do to, kind of counter that, or to be ready to meet with, to see what they're doing?
Yeah, well, I think the first thing that we need to address is the fact that one of the reasons for executive sessions, appropriate reasons, would be an emergency. So to the extent that there is some real emergency, the public hospital ran out of ventilators or whatever, they could meet without and go into executive session to have that meeting, and probably would get away without notice. But COVID-19 obviously is a whole special circumstance. I would say this, that if we found out, of course, with the Hattiesburg case, that the Department of Health has to identify the nursing homes. And so also, I think if with meetings, specific to meetings, the question has come up about, well, what about, they say it's not safe to have the public at a meeting. I think we have to realize that these are special times, but I do think the public body would at least be required to arrange for Zoom so that any member of the public could attend their meeting, not just.
And I'll just jump in here. I'm also happen to be on the board of aldermen of Taylor, the tiny little town. And I know that when we were trying to have our meetings, we checked with the Ethics Commission, and they're and Mississippi Municipal League, and they were sort of like, well, just do the best you can to make sure the public can see what's happening. So FaceTime Live not FaceTime, Facebook Live posting it on YouTube. Now, can they have the meeting? Is there any requirement that they have it live so that people can comment or public, or can, as long as they record their meeting and post it immediately, is that still okay, or does it need to be interactive?
Well, that, of course, it's hypothetical. There's not been any ruling on this, but I would think, to the extent possible, it ought to be live so that people could see and hear it while it's going on.
Yeah.
But having said that, certainly public bodies are going to be given some leeway with these extraordinary circumstances.
Right. Great. Okay. The last thing I was going to say is, so you're at a meeting, you think they're going into executive session, or they're shutting you out, or they're meeting. We had a question from Greene County that I think I forwarded to you. They're meeting all together back in a room and talking about things, apparently, or maybe, or we don't know what they're talking about. And you're wondering, can they do that? When can they get together? What if you feel like you're being shut out of meetings? What's your best process to address that?
Okay, well, we have some pretty clear law on that. Anytime that a quorum gets together, they could make a decision. So that's a meeting, whether they call it one or not.
So three of five, or whatever the number is for that board to make a binding decision.
That's correct. And there is a specific case out there called City of Jackson. It's Gannett versus City of Jackson, where the City Council of Jackson attempted to meet in what they called a retreat, which they said wasn't a meeting. And the Supreme Court said, yes, it was a meeting. Regardless, if you're talking about everybody trying to get along better, you had an agenda, you had a meeting.
Right. Okay. So you're at the meeting, you're a young reporter. This happened to me, my very first meeting I covered, and they went into executive session, and I didn't think that it was covered. So what do you do? What's the best thing for a reporter to do when they're getting ready to do that?
Okay. I think that you should respectfully stand, and if they vote on a reason that you think is not one of those listed in the Mississippi Code, if you think it's improper, you should stand and say, I don't believe this is appropriate for executive session, and I want that recorded in the minutes. That'll be helpful to us later on, should a lawsuit or whatever develop. The other thing you should do is, there is a very simple procedure with the Ethics Commission. If you go to their website, they have a complaint form for both open meetings and public records. And you should make a complaint and back it up with exactly what happened. And as far as if you can get the minutes, that would be good. But in any event, explain exactly what happened. Then the public body will be contacted by the Ethics Commission, given an opportunity to refute what you said, and then the Ethics Commission will decide. So that's a pretty powerful stick. I don't think people realize how powerful, because public officials don't want to be called out by the Ethics Commission. So that's something that I would encourage you to do. Of course, the other option is you can go directly to court, but I think normally speaking, you would want to make a complaint to the Ethics Commission. One caveat, the Ethics Commission is a rather small agency, and so the turnaround time, and the actual commission itself only meets once a month. So the turnaround time on complaints is rather slow. So don't expect that you're going to get an answer the next few days. And that's, of course, that's a problem with the system, because lots of times you need an answer the next few days, but you're not going to get it with the Ethics Commission. But I would still make the complaint, because it will help you in the future. If they are inclined to go into executive session for the wrong reasons, they're not likely to do it if they've already been called out by the Ethics Commission, who has the power to fine them and do other things.
Right. And, you know, you can, it's really important to start documenting immediately who was for it, who was for again, you know, were some of them willing to let you in and some not, you know, because it becomes so I've covered meetings where they wouldn't let you in, and so that becomes the story. And as journalists, we are often taught we don't want to be part of the story. But I had a great editor at the DeSoto Times, Bill Bailey, who was really great about calling you and interviewing you about, you know, like, so if they locked us out of a meeting, suddenly there'd be a front page story and an editorial. Or and the same with TV. It's like, we're standing outside of this meeting. They've gone into executive session. Here's what state law says. And officials hate that. So you can write about it, either address it editorially, or just as the fact that they are not following, at least based on your analysis. And if you can get someone like Leonard or someone at School of Journalism like Charlie Mitchell in our at University of Mississippi, and I'm sure there's some other schools, to just talk in general about what is allowed and what isn't allowed, the readers can see. So that's another option you have, is to just report about it.
Yeah, and that's a very powerful option. I do want to go back and touch just a minute on something you raised earlier about developing a source on the board. That becomes really important when you're suspicious that the board is going into executive session for the wrong reasons. Really early in the open meetings law, we had a case, Gannett, with the Hinds County Board of Supervisors. And what developed was that there were two supervisors who didn't want these rogue executive sessions. They wanted to do it right. Now, I don't know if their motives were totally pure or not, but at least they were on the side of transparency. Interestingly enough, one of those was a very conservative Republican who represented Northeast Jackson, and the other one was a liberal Democrat whose name was Benny Thompson. And they became the source for the Clarion Ledger to be able to report on everything that was happening in executive sessions. The board got so upset about that they asked the Attorney General for an opinion that they could exclude Benny from the meetings because he would tell everything that happened. And the Attorney General said, "No way. Yeah, he's an elected official."
I didn't know that story.
So yeah, that actually happened back in the early 80s.
Yeah, well, that's really great. And someone on the chat has said you could also contact Tucker Carrington, who is in charge of the law school clinics, knowledgeable about legal remedies. Another thing, you know, a lot of times, folks, and this goes for the open records we're about to get to too, a lot of time, the folks that are out there in Mississippi doing these things, they're not lawyers. They're not journalists. They're not up on the records. They haven't been socialized to talk about complicated, touchy, controversial things in public. And so they're going to default. And so oftentimes I've found that, you know, if you can just start to explain to them what the law says and start to talk about what could happen if they don't, if they break the law. And if you do that kind of ahead of time and let them know that you're really concerned and you're very interested in open government, and that so my first boss, he wrote up in Hernando, wrote so often at his little weekly paper about he just have editorials and write news stories every time they locked him out, or he'd call Horn Lake and South Haven boards decided to have a secret meeting to discuss merging the two towns into one town, which you can imagine is clearly every bit of public business. And it was chaired by the Chamber of Commerce, and he called every single board and polled them on whether they knew they were breaking the law, whether they thought this was a good, whether they supported it or not. And then a few years later, I was covering a Board of Supervisors meeting. They were talking about trying to go into executive session. And one of them finally said, you know what, let's just talk about this in public, because if we don't, Bill Bailey will go crazy. And I thought, so there are lots of different ways to try to, sort of carrot and stick to get yourself in those meetings. So I'm going to post at the end of this, I have a slide that has the information about the hotline that Leonard runs and some other things. If you'll put your email in the chat, I can send that to you as well, and some other information. But so let's move on to open records, and then we'll take some questions. So let's just talk what is not available first, because I think that's a shorter list than everything that is, maybe.
Well, I wish that were true. Basically, the public records law, in my opinion, has way too many exemptions. And what is the real problem is that they're not in one place like the open meetings law. So the public records law, the exemptions are scattered throughout the Mississippi Code. And so it's a lot harder to get a handle on those. But you can certainly always make a public records request if you're in doubt. Make the request, then it's incumbent upon the public body, if they're going to deny your request, they have got to tell you within 7 days in writing what the exemption is that they're relying upon. Now, I said 7 days. That can be extended to 14 if they contact you in 7 days and explain why they can't get the information to you in 7. But in no case can it go any longer than 14 days. So I know there was some question about the Department of Corrections that came up. That's the absolute worst public body to deal with in Mississippi, in my opinion. But I think we've got somebody's got to stand up and challenge them. You got to go to the Ethics Commission. They've got to get their hands slapped a few times so they'll start responding within the appropriate time. But anyway, the bottom line is make the request. If the public body says that they're denying the request, they got to give you the reason. And then if you don't think the reason is correct, you collect your request, you collect their response, and you make your complaint to the Ethics Commission with those documents.
Right. And so what kind of costs can they charge you? Because I know that's become an issue with some folks in Mississippi, some things in Mississippi recently.
Yes, it is. It's an ongoing problem. What the statute says is actual cost, meaning what they actually incur in cost. The problem gets to be the time spent by an employee to gather the information. However, the law does say that they have to use the lowest priced person that is capable of gathering that information. Of course, that gets to be a question of fact as to whether some clerk is capable of doing that. Sometimes it's obvious, sometimes it's not. I would always, if you think the cost is high, I would certainly always ask them to break down the cost so you can analyze it. For instance, we have had situations where they went out and hired the most expensive law firm they could find to review a request, really just to try to make it go away, saying that no one in their office was capable of making the legal decision as to whether or not these records were exempt. So again, make your request. Then if the cost it seems excessive, get a breakdown of the cost, and then we can ultimately throw it to the Ethics Commission to decide. I will tell you that the Ethics Commission, as far as copying costs, I think their model rules say 10 cents a page, something of that nature. It's supposed to correspond to the actual cost of providing information.
What about when they're in an electronic form?
Yeah, again, you can request it in any form that they have available. Now, one thing you do need to know, and this is a frequent misunderstanding on the part of people making requests, you cannot cause a public body to create a record. In other words, you can't say, give me a list of all of the expenses you incurred the last 30 days. Now, if you tell them to give you a copy of the records that contain that information, they have to do that. But they do not have to create a list for you. And so you need to always understand that.
And someone in the chat has said, in your records request, I have learned that you should also include a request to provide the appropriate records custodian should the entity you sent the request to deny it for lack of access.
Yeah, I suggest that people send it to the head of the agency and let them worry about who's supposed to respond to it within their agency. So I'd send it to the director of the agency, and then that way we know that person has access to it and could provide it if they wanted to.
And again, just like everything, take notes, take note of the date you sent the request, when you got back. If you have any conversations, write down the times and who you talked with about it. All of that can be useful if you're trying to seek some kind of redress. Just the more you can document your efforts to do it, and you may, one paper I worked at, there was a very controversial decision by and this is not an open records kind of thing, but it was a controversial decision by the DA, and he refused to be interviewed or answer any questions about it. And so we documented every single phone call and every email for like 50 something days. And then we finally wrote a story about how many your requests for information on this that he had not responded to. So sometimes that becomes a story. And he was furious, but he did give an interview after that. So documenting your efforts can be helpful.
And always submit the initial request in writing. You may have some later telephone conversations, but always submit that initial request in writing so you do have the document that shows you did that on such and such a day.
Yes, and in the links that I'm going to have one to the Mississippi Center for Freedom of Information, and it's got all the statutes and so forth. And so you can even cite those particular, it is my understanding that these are open records and I request under this such and such, and I request that, those kinds of things. Okay, so let's just talk a minute about the kinds of things that can be available for reporters that could be useful under Mississippi law, just some of the most common kinds of open records.
Well, I would I think the first thing to note is I would assume everything is open until I am and advise otherwise. I mean, there are some things that would be foolish to ask for, like the personnel record of an employee. You're not going to get that is obviously protected, but that one, the personnel record, is the only one that says it shall not be provided to you. The other things are actually discretionary. They can use the exemption if they wish to, but they don't have to.
Right. And I've covered different police, and I'm about to get to the police. I've covered some places that under Mississippi law, the police chief is happy to give you the report or something like that, or another official in one agency, and then you go to another county and they don't. So they do have some discretion in that, and sometimes they don't even realize that themselves. They take the easiest path of least resistance. Let me ask you this about personnel. So a lot has come up with all the issues about law enforcement and questions about brutality and racism and those kinds of things. Obviously, the individual personnel record of a police officer is not available. But what kinds of disciplinary, can you ask for how many officers have faced disciplinary without the names, or what kinds of things could you get to get a picture of that?
Well, again, it's a matter of whether or not they are willing to do it. You can't have them create a list of how many, but you can, if they have information that meets your request, that is contained in a record, they can always redact information that you're not entitled to. The problem you're generally going to run into with those types of things is they will invoke what's called the investigative exemption. And that is, there's a big hassle about that, and what's investigative and what's not. When does it stop being investigative, or does it? I've had an attorney general argue with me 20 years or so ago that once an investigative record, always an investigative record. Doesn't matter if they don't indict, or it doesn't matter if they convict. An investigative record retains that character. I don't believe that should be the law, but very frankly, there's not a case that says it one way or the other. What you're always entitled to is an incident report. Mm-hmm. Now, that's a pretty bland document, but it sometimes, particularly in small towns, they don't create a separate incident report, so you might get a full report with redactions. If you ask for you're always entitled to that incident report, which is basically who's involved, what the charge was, and where it occurred, and if there was any property, what stolen or whatever, what that was.
What about the jail docket? Can you talk about that? Because I know sometimes you can track down what's happened by going to the jail docket.
Actually, access to the jail docket preceded the Public Records Act. So yes, you are entitled to that.
So you could go over to the jail at any time and say, I want to see the docket of who's been arrested and who's been, and what all is going to be on that for them. Tell them.
Yeah, who's there. I suppose, I don't know that there is a specific format for a jail docket, but obviously the names of the people that are there are going to be.
Yeah, right. And usually, well, the ones I've seen, at least here in Oxford, have the names. It's been a little while. The arrest, what they're, like the charge that they're there, and when they were brought in, at least I think it's.
Yeah, I think that would be pretty common format.
And so if the police aren't going to give you the incident report, but you know that they've arrested somebody, you might be able to find out some information at the.
Yeah, and you're clearly entitled to the incident report. That's right in the statute. So if they refuse to give you that, that's appealable to the Ethics Commission.
Okay, great. Okay, well, why don't we, I know there's more that we could talk about FERPA and privacy of students and so forth in schools and universities, and also law enforcement, but I want to use our time wisely. So why don't we open it up to any questions, if y'all want to just put them in, or just go ahead and, let's see, how do we, you can go down to the bottom and raise your hand. Does everybody know how to do that? Let's see. Okay. So,
as somebody with a finger up.
that's Deb Winger. She knows how to do that. Okay, I see. There's a little hand. So, so go ahead, Nancy DuPont, if you want to go ahead and answer. I don't know if I need to do anything on my end.
She's got to unmute.
Yeah, unmute. Nancy.
I don't have a question.
Oh, okay. You just raised your hand so I could see how to do it. Okay. Does somebody else have a question? Let's see. Sarah says on the jail docket, you can also see which attorney. That's a very good point. If any is representing, and that is true on all the ones I've looked at, representing the detainee. Now, if they're going to have a public defender or they don't have an attorney yet, it might not be there. So one person writes, section 2541.5.3 provides that materials will be distributed to members of the public body, shall be made available to the public at the time of the meeting. Did those materials include a monthly email routinely sent by the executive to his board before each scheduled meeting that presents and discusses items on, like the packet, I think is that, before our alderman meeting, we get a packet every week of material, month of materials.
Yeah, I think the intent there is that it include materials that are going to be discussed in that meeting, and that would be the packet that all of the aldermen receive.
Right, and they could remove, if they had a packet about a specific employee or a lawsuit, they could remove that. But everything else, rezoning information or mayor's report about some proposal or something like, all of that should be a public record.
Yes.
Part of what they include to you. So I don't see any, I'm not seeing any hand raises right now. Somebody says, I missed this. What are the data sets we should be thinking about accessing this fall as schools go back in session? That's a great question.
And I'm sorry, I didn't understand. What is it that they want to
so what are the data sets? So like if they have, and Deb, if you want to add some more, the data set of, what are you thinking, Deb, and specifically, what should we think about accessing this fall as schools go back in session? What does she say?
It said,
I need to unmute her. She can't. Let me unmute everybody.
Yeah, right. Yeah.
Because I'm sorry, I'm obviously not a Zoom. Well.
Okay, I think you did it.
Okay.
My husband would love to have this feature, I know, but in terms of the question, it seems like it's always difficult to get rapid reports from school systems and or universities. Is there a way, I'm sure they're going to have to be tracking what the COVID-19 situation is within the public schools, within the universities, broken down by school and university or by district. You know, what could we be doing now to prepare to get that information?
Well, I think first thing is obviously anything that exists as a record you're entitled to. I would think that it's not otherwise exempt. I would think that they would be making plans now for how they were going to reopen. For example, are they going to go have two different sessions, a morning and an afternoon session with different students? Are they going to discontinue virtual learning, or what their plan would be? I would think that within the next 15 days or so, they're going to have to make a decision on that. So I would certainly think those records would be important.
Right, and what they are be pulling, like what have they compiled to make those decisions? And I think Deb is saying, like, so if they're monitoring number of infections, how do we don't have to know the student or the employee or the teacher or professor's name, but if we've got X amount, can we get to how many infections do we have at the local elementary school, or how many infections do we have in the school district reported?
If there's a document, a writing that contains that information, you would certainly be entitled to it.
Including email. So we've run into this here at the university. So emails, talk about how email what emails are available and those kinds of things.
Well,
public record.
I'll have to compliment Robbie Ward on that one. Robbie is no longer in Mississippi, but when he was with the Tupelo newspaper, asked for the emails. I believe it was the mayor, and it was declined. But the Ethics Commission ruled that any email that's created by a public official is a public business. It's available. So that's one thing that public officials, and Ellen, I would think you as a public employee, that's something they certainly need to be aware of, that if they're making an email, that might show up somewhere.
Right.
As a matter of fact, one public official, and I'll choose not to say who it was, but it was learned that he was having an affair from a general email request. It just wanted all of the emails of that public official for, say, like a week period or 2 week period, something of that nature.
Right. So if you wanted to find out how, say, the state health department and the governor were discussing, like the Dr. Dobbs and the governor, if you want to find out what they were discussing in February and March about closures and what kind of warnings they were getting, you could absolutely request those, correct?
Yeah, you could, if they put it in emails or they put it in any other document for that matter, you have access to it.
There's also some, I had a former student at the Sun Herald who did a really great story on travel authorizations and the State Department of Transportation, and won a bunch of investigative reporting awards, Michael Newsom, for doing that. And one of the things that he found is that once he reported on that, people started coming out of the woodwork, sending him documents and or telling him where to look for more stories. So that's one. So that's another thing to be thinking about. So reports, oftentimes school districts will do reports on drug and alcohol use among the student body, or there's all kinds of documents and things that public bodies prepare that can be great sources of stories that are open records. So the university often hides behind privacy and FERPA for students. And so what are they, and school districts as well, what are they legitimately under the law can they withhold, and what do they need to be given us?
Well, that's a really good question. It's and I can't give you a really great answer to it because it's still an open issue. But I will say we have been able to get some records involving athletic departments and disciplinary proceedings, not individual names, of course.
Right.
But and clearly we're not entitled to the academic record of the student. I think that's what FERPA was intended to protect. But the problem is that what you will hear from schools, universities in particular, is they could stand to lose all of their funding if they give you a record that the Department of Education later decides was not appropriate. So they just take the easy way out and say, no, you can't have it because of purpose. So
right.
You're going to have a tough time with the university on that issue. Also, right. Universities are notorious for hiding donor records.
Yeah.
And I think that those should be available. What they will claim with those, they will claim that the foundation is a private corporation. And other states, in some other states, it has been decided that if the overall body, the university, would have to do that function, but for this private entity, that should be considered a public body for the purposes of records. But I can guarantee you, if you send a request today to the University of Mississippi Foundation, you will be denied, and as well as the athletic foundation.
Has anybody taken that to court?
Not in Mississippi. I've longed for somebody to. But it now is very unusual for newspapers to go to court, and they're about the only ones that ever will. We when back a few years ago, it was very common. But now with the financial issues, it's tough.
Well, I think, and one thing I want to encourage the folks on here is to think about joint filing. If you've got even a lot of times there's not that many places, unfortunately, these days where there's more than one reporter from more than one entity covering something, unless it's, Jackson or one of the cities. In a lot of these counties, you might be the only one. But, I competed against a lot of reporters, but as soon as they started encroaching on open records or open meetings, we stood shoulder to shoulder. And so, if somebody is willing to, especially with these health documents or some of the statewide things, if you could share the costs across multiple news organizations to join it, I would encourage you to do that. I worked for a paper in Charleston, and we had an attorney on retainer, and lots of your news organizations probably do. They need to do something to earn their money. Get them to write a letter for you, if nothing else, or make a phone call. Ask your boss if you've got an attorney on retainer, and if they're willing to, because sometimes that's all it'll take, because those other places don't know how far you're willing to go. And when they get a call from an attorney there, they might back up a little bit. Is that sound advice?
Yeah, I mean, absolutely. I've represented the Clarion Ledger for many years, and I've written many of those letters.
Right. Well, and I'm a lawyer's daughter, and my brother and uncle and everybody, lawyers all over the place. But the first thing they tell me is, don't ask your attorney or any attorney, can I do this? Ask them, how do I do this? Because their easiest thing to say is no. So whether you're talking to a board attorney about getting documents or open meetings, or if you're talking to your own attorney, say, this is what I want, this is what I need, how do I get it? How can I get it? So anything else that anybody has, please put your emails in the chat. I'm going to save the chat. And let's see, I see one message. Oh, yes. And I'm going to send let me put the slide, share the screen with the slide with the information, and I'll email it too. But it's just some websites. Where the heck did I, there it is. Let's see, desktop. No, that's not what I'm, wait, share. Nope, that,
Yeah, there's something that says our government.
Deb, don't judge. I do this a lot better with my classes. I've forgotten how to do it. Deb Winger's on here. She's our dean, and I'm like, don't judge how I'm zooming by how I'm running this, how I'm teaching by how I'm running this. But here it is, and if you'll put your information in the chat, I'll save it and I'll send you some emails. I'm also thinking about doing a couple of other ones of these little sessions about reporting on local government or other special topics. So I may be emailing you for suggestions or polling to see what people would like to see. So, but there, right here, you've got the Mississippi Center for Freedom of Information. It's mcfoi.org. There's a handbook there that you can order or download with a lot of these answers, the hotline information. There's a National Freedom of Information Center. We sent this out to high school journalists too. So if any of y'all are there, the Student Press Law Center is great, or university students, reporters. I love the investigative reporter and editors website, and they have a new edition of their handbook out. So all of those are good, and I will email those to you as well. But thank you all so much. Oh, anything else? Let's see. Thank you all for coming and for all the hard work that you do. Thank you so much, Leonard, for your great insight and being willing to jump in on this for me. And we will, hopefully you'll get some calls from your hotline, because I want to know more about this whole COVID-19 thing. It's very anxiety. I wish officials would realize that the more information they give out, the less anxiety and the less problems they have down the road, especially in an issue with a pandemic like this. And more transparency, the better. But okay, bye everybody. Thank you so much.
Bye.
I'm trying to figure out how to save this chat.